So good afternoon, everybody, and welcome to this being our second in a two-series webinar on the subject of data protection. For those of you who might not have been able to join us last week, the first part covered the substantive provisions of the Data Protection Act, whereby we highlighted the salient provisions of the Act, went through some relevant jurisprudence, and also offered practical tips as to what one should look out for in terms of ensuring maximum compliance with the provisions of the Act. Today, in the second part of this series, we propose to highlight the draft regulations that have been made under the Act. And for this purpose, we are extremely honored to have with us for participation in today's webinar from the Office of the Data Protection Commissioner, none other than the Data Commissioner herself, Madam Immaculate Kasait, MBS. Now, for those of you who might not be aware, Ms. Kasait is the current and first occupant of that office, being Kenya's first Data Commissioner. She was appointed on the 16th of November 2020, following a competitive recruitment process from which she obviously emerged tops. In addition to that, Ms. Kasait is an advocate of the High Court. She's also a holder of an executive MBA from the University USIU rather, as well as an LLB from the University of Makerere. Prior to that, she was also a distinguished director at the IEBC, where she served for a period of approximately 11 years. So karibu sana, Madam Data Commissioner. We are most humbled and pleased to have you here.
Thank you, John. I'm also happy to be here this afternoon.
Asante. Now, before handing over the floor formally to Madam Kasait, I'd also would need to introduce the people you see sitting here with me from Oraro and Company, and also to speak briefly about the company. Oraro and Company, for those again who might not know, although I trust that most of you, by virtue of being here, do know something about us. We are a leading law firm within the Republic of Kenya, having been established in 1977 by Senior Counsel George Oraro, making us approximately 44 years old. We are a full service firm, which effectively means that we offer a wide spectrum of legal services, both locally as well as regionally. And this spans from arbitration to litigation, commercial and real estate, as well as emerging areas such as fintech, PPPs, and projects. We also do offer services in the more traditional areas of law, such as tax, banking, as well as finance. We are consistently ranked in leading international directories, including Legal 500, Chambers Global, as well as ILFR 1000. We have also recently joined as an affiliate member the AB and David Africa Network, which is a Pan-African legal network comprising of various firms spread out across various jurisdictions in Africa, which has the effect of pronouncing us more poignantly across the continent. For further information on us, you are free to visit our website or follow us on our LinkedIn page. In as far as the speakers we have today, I'll just briefly set out their names as we run through their bio. That's me, John Baluto. I'm a partner in the litigation department with 12 years or so experience. Next is Jacob Ochieng, who's a partner in the commercial department with slightly over 10 years experience, as well as having of note ranking in the Chambers Global as a commercially astute and one who always looks out for his clients' best interests. We then have Daniel Okoth, who's a partner in our litigation department of over 7 years experience and with vast experience in various areas of the law. Millie Mbedi is a senior associate in our commercial department and who also enjoys vast experience amounting to 7 years plus. And lastly, but certainly not least, is our hardworking associate in the commercial department, Ms. Nancy Kisangao. So briefly, that is the team who shall keep you engaged for 1.5 hours. In terms of the presentation outline, Kasait will take us through an overview of the Act as well as the regulations, and possibly also introduce anybody else who might be from the Office of the Data Commissioner from our end. I will then go through the registration of data controllers and data processors. My colleagues, Millie and Nancy, will then tackle the general regulations, whereas Jacob Ochieng and Daniel Okot shall address you on the compliance and enforcement regulations. The entire presentation in terms of us presenting should take roughly around 50 or so minutes, after which we shall have a Q&A session after that. So without further ado, I would now hand over to Madame Kasait for her address.
Thank you, John, for the elaborate introduction. And I also want to appreciate the attendees of this webinar. I am joined this afternoon by Anne Nganga from my office. I don't know, Anne, if there's anybody else. We had requested 1 or 2 members of the task force to join. I'm not sure if they're on board. I'll introduce them as we proceed. I'll proceed to share the presentation on the office and what our status is in terms of implementing the Act and where we are in terms of regulation. I'd been advised somebody from the office, from your office, John, will be sharing the presentation.
Yes, indeed. So, okay.
Next slide. We can move to the next slide. Yes. The content of the presentation, I will give a background in terms of the digital economy. I like to ask, why is the Data Protection Commission situated in the Ministry of ICT? And why was it important for Kenya to have data protection legislative framework? And this emanates from the Kenya Digital Economy Blueprint. And in the Kenya Digital Economy Blueprint, it has 5 pillars. And the pillars are clustered under policy and regulatory, emerging trend and data. The first pillar is on digital governance. The second pillar is on digital business. The third pillar is infrastructure. The fourth pillar is innovation-driven entrepreneurship. And the fifth pillar is digital skills and values. Below the pillar, we have government, citizen, and private sector all feeding into each other. And we foresee a state where we'll have an integrated, all these are supposed to contribute towards an integrated ecosystem, a green ICT, and security. If you look at the digital economy pillar, the ecosystem, one of the cross-cutting issue is data. And that is the reason why data protection found its way in terms of discussions and how, in order to implement, to enhance the implementation of the Kenya Digital Economy Blueprint, it was important to have a legislative framework on data protection. Next slide. So as you're aware, and I'm sure this was presented last week, the Data Protection Act was enacted in 2019. The office was established in November of 2020. We are slightly over 7 months now. The Act basically provides the framework for the right to privacy and as it applies when it comes to personal data, the practices, safeguards, rules, transparency, and responsibility, how to collect safe collection of data, process, storage, and also disposal. The Act, of course, shifts the control of data now shifts from institution to the data subject. So a lot of responsibility. The data subject is empowered under the Act to start asking questions as far as collection of their data is concerned. Next slide. The mandate of the office, which you also spoke about, I'm sure, last week. So no need to go into it. Of course, apart from the regulating the processing of personal data, ensuring that it is processed in accordance to Section 25, we are responsible for privacy of individual, protecting the privacy of individual, putting in place legal and institutional mechanism on data protection, and also having remedies for data subject in as far as their protection of personal data is concerned. Next slide. The functions of the office, one is enforcement and implementation. The second function of the office is registration of data controller and processors. And this is well articulated in the Act. Once the regulations come into place, one of the expectations is that we will register all data controllers and all data processors. Oversight, promotion of self-regulations, and this is important to underscore that we encourage data controllers and processors to do self-regulation, conduct assessment, and of course, in case there's a data breach, we are empowered to undertake investigation. Next slide. Create public awareness, and that's why I was happy to join you, because part of the priorities for this office is to conduct public awareness. I believe this type of platform gives us that opportunity to be able to create awareness. Conduct inspection, international cooperation, research, and any other duties. In the last 3 months, we've been able to join the Common Trend Network, which is a Commonwealth organization for data controllers, data protection authorities, and also we've just joined the one on the African continent. Next slide. So, which is the topic? Your topic of discussion today is on draft regulations, which I'll just give a highlight in terms of constitution of the team and what it contained, and then I'll leave John and Tim to continue in terms of the details. You may be aware that on the 15th of January this year, through a Gazette notice, the Cabinet Secretary Joe Musheru, ICT and Innovation, actually gazetted a task force comprising of members who come from across various government agencies. The terms of reference for the task force basically was to undertake a comprehensive audit of the Data Protection Act, to, upon audit, undertake gap analysis or inconsistencies in the Data Protection Act 2019, and of course, make specific recommendations for review. 3 was to develop the data protection regulations. We have 3. 4 is to sensitize stakeholders and public on data protection regulation, and 5, undertake stakeholder and public consultation on data protection general regulation. Next slide. Before I go into the details of this, previous slide, please. Then, okay. The draft regulation, yes, they're the terms of reference. Thank you. Terms of reference for the task force. Previous slide. Yeah, on terms of reference number 4, that we have extended the CS has extended the timeline for the task force to allow us to do sensitization of stakeholders on the draft regulations. Our proposal is to actually undertake town hall meetings. Initially, it was not we were not able to do this when we planned to, but also strategically, we thought it's better to do this once the regulations are finalized, so that we are speaking from a point of information that is already accurate, so that we did not want to undertake this before that process was completed. So that it's important for me to underscore that, and that's why we keep saying as an office, the priority is actually on compliance and awareness creation. So awareness creation is part of the term of reference number 4, and I can say that we are more or less 80% completed the task in as far as the task force is concerned. In the next slide, I will just give a high level of overview of what the regulations are, since the team from Oraro will take you through the different regulations. So the first part on the regulation, the first regulation, like I said, we finally came up with 3 sets of regulations. The first one is the Data Protection General Regulations 2021, which basically sets out the procedure for enforcement of rights of data subject, as well as elaborating the duties and obligations of the data controllers and processors. The second set of regulation is the one on compliance and enforcement, which basically outlines the compliance and enforcement provisions for data for the data commissioner, data controllers, and data processors. In the third set of regulation, the registration of data controllers and data processors, which sets out the procedures the office will adopt when it comes to the registration of data controllers and data processors in accordance to the Act. Next slide. So those are the highlights of the general regulation, whether it's the right of data subject, restriction on the commercial use of data, personal data, obligation for data controller and data subject, data protection by default or design, notification of personal data breaches, transfer of personal data outside Kenya, conduct of the data protection impact assessment, and provision of exemption under the Act. Next slide. The regulations on data on registration basically look at nine areas on the scope: eligibility, application for registration, registration of public bodies, verification, certification of registration, renewal of registration, refusal or renewal, exemption from mandatory registration, and registration of data controller and data subject. And the particulars requires is change of particulars, cancellation of variation of fee, regulatory fees, certification fee, replacement of registration certificate, electronic registration, and offenses. And finally, on the compliance basically we look at how the complaints will be handled and the enforcement provisions. Next slide. This is just an emphasis of how many meetings we had with stakeholders. We had 17 virtual meetings, and as well as 3 virtual public participation forum. Of course, like I said, we're in the tail end of compiling the comments and submissions. We hope to have a meeting of a pre-publication meeting with the National Assembly. Next slide. Key issues we received during the public participation. One was the review of the data localization requirement, cross-border transfer of data, duration of renewal of certificate of registration, reduction of registration fee, automation of the process of the data commissioner. We also people sought clarification and simplification of the complaint handling process. They also requested for harmonization of the commercial use of personal data with existing legislation, There were questions around the ratification of Malabo Convention by Kenya and the time of implementation. That is really the highlight. And our way forward is our front pre-publication with the National Assembly. We have awareness creation, and of course, there'll be part about compliance. I think that brings to an end my high-level overview of the regulations. I thank you, and I pass on the baton back to John. Thank you.
Thank you so much for that, Madam Kasait. We are truly grateful. You have provided to us a most elaborate overview of where we are in our act and regulations, and what your office has done in the short time it has been in office, and also what the future portends in terms of the coming into force of the regulations. So without further ado, I shall go straight into the regulations on registration of data processors and data controllers. But first, reminding us all, what really is the purpose behind regulations? Regulations provide the process or procedure in terms of enforcement or compliance with an act, whereas the act provides for the substantive provisions of rights and obligations. So in very high level dichotomy, regulation set out procedure, act sets out substance. So bear that in mind as we go ahead. So that, for instance, if the act says you should not be putting yourself out as a data processor or a data controller without registration, the question that you'll then ask yourself is, how do I actually go about and register myself? So that's what the regulations make clear. So the data protection and registration of data controllers and data processors regulations are still in draft form, as has been indicated by the Data Commissioner, and the same shall come in force by way of publication in the Kenya Gazette as and when they are ready. But let's just talk about them in terms of what they provide in draft form, so that when they do come into force, we are already halfway through in terms of compliance or knowing what you shall be required. So these are made pursuant to Section 18 of the Act, which provides that no person shall act as a data processor or data controller unless registered with the Data Commissioner. And then the same allows for the Data Commissioner to prescribe a threshold for mandatory registration. So Regulation 4 provides for the registration by either a data processor or a data controller in line with the definitions of those persons under the Act. So you need to go back and remember who is a data processor and who's a data controller under the Act. Again, for brief highlighting, a data controller is a person who decides or determines the purpose for which data is being processed, whereas a data processor is the actual person who processes the data. The regulation also provides that you can register as both. And this ordinarily comes into play if you're not a very large organization and you have not outsourced some of the data processing functions, and therefore you are at liberty to register as both a data processor as well as a data controller. Regulation 5 then provides for the actual form. It takes the shape and style of what is called Form A, which is in the first schedule, and that the same should be accompanied by the fees set out in the second schedule. The form is also to be accompanied by a copy of the documents that set up the organization, so the establishment documents, so it could mean certificate of incorporation and the like, as well as the details of the data controller or processor in terms of the name and contact details of the relevant officers there. It is also necessary to include in your application the purpose for which data is being processed, as well as the categories of that data being processed. Now, upon receipt of this application, the Data Commissioner is obliged to verify the details provided in that. And upon being satisfied that the application does meet the requirement for registration, the Data Commissioner shall then issue the applicant with a certificate of registration with a period given there of 14 days for that purpose. Now, once that certificate is issued, it will be valid for a period of 1 year, and it is required to be displayed in a prominent or conspicuous position within the principal office. If the organization operates branches, certified copies of that registration certificate should equally be displayed in each branch as and where applicable. Now, having said that it is valid for a period of 1 year, what you then need to remember is that as it draws close to expiry, a period of 30 days before expiry of that registration certificate, you should then apply for its renewal 30 days before it expires. And the reason you need to remember this is because failure to do so, you then fall afoul of the Act in terms of what is stipulated under Section 73. And it is a penalty that is quite stiff in terms of the fine applicable, up to a fine of Kenya shillings 3 million, or imprisonment of up to a term of 10 years, or to both. So very steep penalties provided for non-compliance with either registration or renewal. So it is a matter to be taken seriously. Now, obviously, the data commissioner is not obliged to grant the certificates upon its application. She does have the power and discretion to decline registration application, but she should then notify the applicant together with providing reasons for the decision of declinature or rejection. Now, once you as the applicant receive the reasons and decision notifying you of your being rejected, or you can then, upon complying with what it is that will have been indicated as the reasons for rejection, you can then reapply afresh. So take that in mind, that rejection is not the end of the world. All it will do is put you in a position to comply by making it very clear why it is you've not been successful. The regulations also provide for exemption. So not everyone is strictly required to apply for registration, either as a controller or a processor. And the exemption is twofold. One, that you don't have revenue or turnover exceeding 5 million shillings. And two, if you have employees less than 10 in number. The key point to note here is that these provisions both of them need to be satisfied. In other words, they're conjunctive, not disjunctive. So remember, 5 million and below, then you're exempt, but you must also not have more than 10 employees within your establishment. But there's also another catch to that, which is the third schedule. There's a list of data processors set out in the third schedule, 19 of them to be precise. And if you fall under that third schedule, then it's still a mandatory requirement for you to register, even though you have less than 5 million in terms of turnover, or you employ less than 10 people. So have a look at the third schedule. There are 19 or so business types or natures of processing that are set out. And then if you fall under that, then you are required to register as a matter of law. Regulation 13 then requires the data commissioner to maintain a register of all data processors and controllers and to keep it up to date with all relevant details. If there are any changes to the particulars of a data processor or a data controller, then that should also be notified to the data commissioner in writing, whereupon that will be updated on the register, and a certificate of change of particulars will also be issued. Again, it's important whenever there's a change in that regard that you do notify the data commission, because breach thereof also attracts a sanction or penalty, as earlier indicated under Section 73, 3 million shillings for 10 years imprisonment. Regulation 15 allows the data commissioner to cancel or vary the conditions for registration, where she is satisfied that there has been either false or misleading information that has been given in connection with the application, or that the data processor or data controller has otherwise willfully breached the provisions either of the Act or the regulation. Under Regulation 17 and 18, you are then allowed to apply for certified copies of the certificate of registration if you need one. So remember that the certified copies which you are to display is not for you to certify yourself. It's actually the data commissioner who should issue those certified copies. And also, if you ever need a replacement copy because of either being lost or damaged, then you're also able to do that by way of application to the data commissioner and obviously pay for the requisite fees. Key to note under Regulation 19 is that the mode or means of applying is electronic. So there shall be no physical attendance to the data commissioner's office. You require to submit them through electronic means. So with that, I will then hand over to my colleagues, Millie and Nancy, to take us through the general regulations.
Thank you, Mr. Mbaluto. So as has been elaborately explained by Madam Kasait, the data protection general regulations essentially discuss the rights of data subjects, how to transfer data, the concept of data localization, amongst other issues. So I'm going to take you through the concept of enabling the rights of a data subject. As you will recall from last week's conversation, data subjects who are generally or basically defined as natural persons have about 5 rights. The right to be informed of the use of their personal data that has been collected. They have the right to access the personal data that has been collected. They have a right to object to the processing of that data. They have a right to the correction of data that has been collected, which is basically their personal data. And finally, they have a right to request for the deletion of that data. So the general regulations basically expound on how these rights can be enabled or how you can exercise these rights as a data subject. For data controllers and data processors, what they need to know is that you need to inform the data subject of the nature of the personal data that you intend to process. You also need to inform the data subject of the scope of the personal data that you need to process. You also need to tell them of the reasons for processing that data, and we'll see why that is important later on, and whether that personal data will be shared with third parties. You remember the concept of consent. So when you're obtaining that consent from the data subject, then you need to detail these things to inform the data subject of these issues. My colleague Dan explained these things very well last week during our presentation on how this concept of consent is very important in this era of data protection. So how can you do this? How can you inform our data subject of all these things, of scope, of the nature and the reasons for processing, and whether it will be shared by third parties? The regulations provide that you can do this by posting it in a public notice, which is accessible to the data subject prior to the collection of the personal data. So when you're obtaining the consent from a data subject so that it is lawful, the collection is lawful. Remember this concept of lawful that my colleague, Mr. Mbaluto, explained last week on the principles of data protection. You need to ensure that the data subject actually has the capacity to understand and communicate their consent. This is very important. And also that they also have to communicate to them that to ensure that that consent has been voluntarily obtained and that the consent is specific and that the person has been informed of how that data is going to be processed. So you see, this consent can either be oral or it can either be written. To err on the side of caution, I will propose having it in a written form. And this written form can even be effected through handwritten signature. It can be through an electronic medium or any other medium where you can confirm, or rather you have the evidence to confirm that the data subject actually gave their consent. So just the next slide. So the regulations emphasize that consent cannot be implied. Your data controller or even a data processor cannot proceed on the basis that a person has not given consent and has not objected to a proposal to give consent because they did not actually do it in a particular manner. And in fact, when you're obtaining that consent, a data controller or a data processor is required to inform the data subject of the implications of providing, withholding, or withdrawing the consent. You will notice that recently for entities which are governed by the GDPR have amended their terms and conditions to reflect this. You will wonder why. It's because of the compliance with the Data Protection Act. Kenya has joined the bandwagon, and data processors and data controllers are required to comply with this going forward. On the concept of collection of personal data, the personal data, basically data controllers or data processors cannot collect personal data either directly from the data subject, from publications or data databases, surveillance cameras, web browsing. When you're web browsing, that information can be collected by cookies, and finally by biometric technology. So what should you consider when you're collecting data from data subjects? There are four things that a data processor or a data controller needs to consider when they're collecting personal data from data subjects. One, you should ensure that you are permitted to collect that data. How are you permitted? By obtaining consent from the data subject. Another thing is you should put in place safeguards to ensure the quality of that personal data. Quality of personal data relates to the fact that that data is up to date, amongst other things. The other thing is to ensure that you have appropriate safeguards to ensure the security of that personal data. And finally, you remember the concept of sensitive personal data. You can only collect sensitive personal data, which is data relating to the marital status of the data subject, the property details, the sex, gender, and whatnot. You only can collect sensitive personal data directly from a data subject. So you cannot collect it from web browsing, from databases, from publications, and whatnot. And if you when you're collecting a personal data, make sure that you've indicated the purpose. And if that purpose changes, the regulations require that you go back to the data subject and obtain consent afresh. So moving on to the specific rights and on how to exercise those rights, we have the right to the transfer of data, or rather data subjects have the right to transfer their data, to apply for the transfer of their data from one processor to another. You can do this through a prescribed form, and the data processor is required to provide that data, or rather transfer that data within 30 days upon payment of a fee. And that fee should not be exorbitant, it should be reasonable. And then they're supposed to notify the data subjects within 7 days if they intend to decline, or rather they intend they don't intend to transfer that data. So moving swiftly to the concept of restrictions to the processing of personal data. Just to emphasize on that point before we move on to this concept of data transfers and data localization, you recall I mentioned that data subjects have the right to restrict the processing of their personal data. So they can do so if they contest the accuracy of that data, that they also can confirm that it has been unlawfully processed. If you feel like as a data subject that the personal data has been unlawfully processed, then you can apply to the data processor to restrict the processing of that data. And also if the data is no longer needed, then you can apply to the restriction of that personal data. So I will invite my colleague, Nancy Kisangu, to discuss the concept of data transfers and data localization as envisaged under the regulations.
Thank you, Millie, for that elaborate discussion on the regulations enabling the rights of data subjects and the restrictions on the use and control of that data. So we just move on swiftly to talk about data transfers, data localization, and data portability. So I think the key point to begin with right now is from what Ms. Immaculate Kasai just mentioned, that the move to the data protection regulation is actually a move to a very data-centric and subject-centric regulation of data, where data subjects have more control over their data. So one of those means is what just Millie has just previously talked about on data portability. So other than data portability, the control is also exercised on the restrictions placed on controllers and processors on where they store their data locally and what happens when they transfer that data. So we'll just begin with data localization. And these are the restrictions on the geographical limits within which data can be stored in Kenya. So currently, the concept of data localization applies to data processors and data controllers where personal data is being used for a public good purpose. And why we are having this is because data is borderless. The internet currently, being one of the largest data sets that we have, is borderless. There are no restrictions as to where data can be stored, how data can be used. So if you have subject matters on national security, where you have civil registration system, it could be important, and it's actually quite important for states to regulate where this data is stored. So currently we have instances of public good, and that is the current restriction under Regulation 25, that where we are having data used for public good, then there is a restriction on the geographical limits within which data can be stored. And that is why we have a requirement for data localization. So practically this can be shown in instances of cloud computing. As we move on to a digital age, we are having more reliance on cloud computing. So the concept is that if you're having data that pertains to a public good, if you're a data controller or a data processor who has been contracted to have data that is used for a public good, then essentially your servers and your data centers have to be within the localities of Kenya. So I think it's a good move that moves towards the territorial integrity of data that is quite important and of a nature that impacts the system in itself. So it is a good concept. So we're moving on swiftly. Other than data localization, what the regulations prescribe in terms of data transfers is that there are restrictions on data transfers, which border on first on the restrictions of geographical limits. And what I think is very interesting to note under the regulations is that we are having the concept of transfer. Well, the term transfer itself has not been defined within the regulations nor the acts, but there is a consideration that even when the data is in transit in Kenya, that is the next slide, please. When we have data that is in transit in Kenya, then that application of the Data Act itself and the regulations will actually apply to such data insofar as that data is going through the country. So this is a move actually when we're bearing on geographical limits. This is a move to introduce the territorial limits on data on a borderless world. So there is an exclusion that we do have on network service providers, and it will be interesting to see going forward how that will work in terms of restraining the intermediary liability that network service providers such as telecommunication service providers will have in terms of data transfers in Kenya. So insofar as we're talking on data transfers, there are the safeguards that are required to be in place there in terms of ensuring that the data is being transferred to a locality where there are adequate data protection safeguards. We're having the consent of the data subject in terms of sensitive personal data, and we are having the transferring entity assuring that this data, insofar as it is being transferred to a third entity, there are adequate safeguards. And how to determine those safeguards has actually been set out by the acts and by the regulations. So we're looking at countries that have ratified the AU Convention on Cybersecurity and Personal Data Protection. We're looking at countries that have reciprocal data protection agreements with Kenya, and we're looking at countries that the data commissioner has actually consented and say that these specific countries have adequate data protection mechanisms. If we were to just have a slight comparison, maybe just on the same slide, sorry, if we were to just have a slight comparison on what is happening in other jurisdictions, such as the UK, we do note that the ICO and also within the EU regions, that is the ICO, the Information Communications Officer in the UK and the respective EU official in terms of data on data protection have all in their own instances set out countries where they have determined that they have adequate data protection mechanisms. So that is all that we have on data transfers, in that basically what you have to do is you have to ensure whether that these safeguards apply to you in terms of transfer. And in the event that they do, you are required to have data transfer contracts, just to ensure that there is a written mechanism setting down how this data is going to be transferred, where it is going to be stored, who can use it, especially in instances where we have data in transit. What we are looking to see going forward is maybe instances where data has been accessed through our website portal. As you can note, so far we have been saying that data portability, data localization, and data transfers are all an attempt to ensure that we have border descriptions in a very borderless world. So practicalities as to how data is being accessed in areas where we have borderless communication and seamless communication, such as the net, are really interesting things we want to see from a practice perspective. And we're really keen to see how these developments are going to shape data protection and data regulations. So having looked at data protection and data transfers and data localization, we're just going to take a step back and see, if you're a data controller, if you're a data processor, what are these things that you need to ensure that you have within your organization such that you are in compliance. So yes, I am a data controller. I am transferring, say, gigabytes of data in a daily basis. In terms of compliance, how can I ensure that I am on the right side of the law? So we look to the concept of data protection by design and default, being that the Act itself prescribes that if you're a data controller, if you're a data processor, you have to ensure that you have data protection by design and by default. So when we talk about data protection by design, we mean that your organization has to have technical measures that set out data protection. So let's take it to a basic. If I am a developer, for instance, I have to ensure that when I am running a company, if I do develop software on a daily basis for third parties, I have to ensure that my organization has specific policies that set out how data is being processed, how data is being collected, how data is being used, even not on the product itself, but as I run an organization. So as a law firm, for instance, we also process a lot and huge chunks of data. So we need to have regulations on how data is being collected from client care, how we using that data, how we disclosing that data, in as much as advocates, of course, we do not disclose data based on client confidentiality, but we need to ensure that we do have a mechanism within the own organization's code of conduct on how data is being used. And that is why you will see within the DPA, they're asking that you need to have a data protection officer, in as much as it is better off to have a data protection officer who can sit down and ensure that you have data protection mechanisms. You are also required under the regulations to have a privacy policy setting out how you're using and disclosing that data. So when we go to the regulations themselves, what they do is that they expound on this concept of data protection by design and by default. So the explanation is made and based on the principles of data protection. So we begin by the first principle being the principle of lawfulness. Lawfulness essentially is looking at to how have you acquired this data? Have you acquired this data on a legal basis? So for instance, I am a social media website. How have I acquired the data from my users? Have I acquired data based on the contractual basis that we have, that is on the terms and conditions that they are signed up on? Or have I accidentally snooped into their messages and acquired certain data about them? So lawfulness says that if you're developing an application, say a social media website, the data that you acquire for them has to be lawfully acquired. That is data that the user is already aware that they're giving out to you and they have consented to giving out that data, or where you're acquiring such data indirectly, that the data subject is aware that you as a social media website, you can acquire this data indirectly. Transparency talks to awareness of the data that is being collected. So for instance, you do not want to have a website that is collecting data that you're not aware of. You need to be aware at all times that this app is taking on data. It may share the data with third parties. It will store their data in Kenya or not. purpose limitation is as to the purpose of this data that is being collected. So for instance, if I am collecting data from you for the purposes of paying bills, then the same data should not be used for the purposes of determining, say, my credit worthiness or what food I should purchase the next time. So we move on to the principle of integrity, confidentiality, and availability. Integrity means that the systems and the structures that you have placed in at all times are not exposing your data to known vulnerabilities, to data breaches, so that essentially the application that you've developed, if you're a software developer, if you're a company organization, that your data is not exposed to, it's not vulnerable. Where have you stored this data? Have you stored it in cold wallets when you're dealing with cryptocurrencies, or have you stored this data in a server that is not well protected and safeguarded? And we go on to the fifth principle, that is data minimization. And I think we have seen a current and live example of this, where we've had one of the largest telecommunication and mobile services provider take on affirmative steps to ensure that the data that is sent out on the payment of bills is not exposed. So you have data minimization. And I think currently they're only displaying the first digits and the last digits, effectively hiding the main digits, which will be identifiers of who this person is in terms of payment of bills. And then we also are required to have, you are required to also ensure that the data that you store in terms of data protection by design and by default is accurate. So this is where you see that the regulations have a shift, that you have more control as a data subject. If an organization has data that concerns you that is inaccurate, then you have the right to also just write to the data controller and say, hey, this data is not accurate. I would like this data to be rectified. And then finally, you have the last principle on data protection by design and default is on storage limitation. How long can this data be stored? Do you want this data to be stored for eons? Do you want this data to be stored for a day? So you have to remember that all these principles apply in tandem. There's not one principle. You cannot just say that you fulfill the principle of lawfulness, then you do not want to fulfill the principle of storage limitation. So when you're designing, say, be it an application, say you are setting up your business, these are things that you need to be aware of and have them at the forefront of your mind, that yes, I am in a business that deals with a lot of data. So in terms of my structural and organizational designs, I need to ensure that the data I collect is stored in a lawful manner, in a transparent manner. The purpose for which this data is collected is limited. It is stored in an integral manner. It's going to be confidential, because we also have to remember at the back of our minds, and I think this is something that Mr. Mbalito has echoed, that if you don't comply with these requirements, there are penalties that accrue to you by virtue of not complying with these requirements. So it's quite important, even as we go forward, to ensure that data protection by design and default is at the forefront of your organizational storage. Next slide. And just moving on from what I've just talked about, there are consequences. What happens if there's a breach, and how do you notify it? So I think last week that was adequately covered. So what the regulations here are really covering is the concept of real risk of harm. So if our last, I think I can recall from our last presentation when we talked about breach and notification, we talked about how the notifiable breaches under the Data Protection Act. And one of the notifiable breaches is when you have a breach that considers a real risk of harm. So the regulations expound on what the real risk of harm is by setting out what it amounts to. So there are various prescriptions that have been set out under the regulations, but just for example purposes, this is a breach where a data subject's full name, identification number is disclosed. We have to remember that information relating to a person's name, gender, sexual orientation is sensitive personal data, because they encompass the entirety of this person in terms of developing a digital personality. So if you have my name and you have my identity, it is very easy to be able to access a lot of information around me, or maybe credit worthiness. So when you have such breaches, you're required as a data controller and as a data processor to actually notify the data commissioner within 72 hours. And when you do not do that, you have to give the reasons for that, for that delay in notification. So what the regulations have done in this case is just to expound further on what the Act means when they talk about the real risk of harm and what you should do when you encounter a real risk of harm. Just almost winding up, we just are building on your obligations as a data controller, as a data processor, and intertwining that with the more control that a data subject has. We're going to look at data protection assessments on the next slide. Next slide, please. So the data protection impact assessment is an assessment that you need to carry out where you're dealing with data that is highly that has a high risk. So the Act provides that you need to carry out a data protection impact assessment and also submit this to the data commissioner just before you begin such processing. So because the Act is not clear, the regulations fill in on what amounts to high risk. So high risk, we're looking at automated decision making. For instance, if you're using AI-based mechanisms for, say, market automation, just to target market users, if you're using this on a large scale for a purpose other than what was initially collected. So for instance, if I am say a marketing agency and I collected data just to determine if they like a brand of soda, if I'm going to use the same data just to determine what restaurants they normally visit, that's a different scope. So that becomes a high risk operation, and you need to carry out a data protection impact assessment before you can continue carrying out. If you're using data, if you're processing biometric genetic data, if you're using a single processing operation and you're grouping it with other processing operations. So that point ties in with the first example I gave out, that if you're using data and you're a market agency and you collected data just to determine if people like one brand of soda over the other, and you want to use such subset of data in a larger subset, for example, just to determine what are the best restaurants to go into, you will need to carry out the data protection impact assessment. I think they're more than that, and you can see we've set them out elaborately. But just for the purposes of time, I think it's good just to move on to the exemptions, which is the final bit, which are the two final bits of my presentation as to the exemptions that have been given out on data protection. So under Section 51 of the Act, there are exemptions, and one of the exemptions prescribed under Section 51(2) is the exemptions for national security purposes and for public interest. For national security, the data protection regulations have codified what it means to have national security, because it is an overly broad concept. So the limitation in the regulations in this instance is just the provisions of national security as prescribed as national security organs in the Constitution. So currently, these are the Kenya Defense Forces, the National Intelligence Services, and the Kenya Police Service. So those are the three exemptions that apply for national security. And when we move on to public interest, we have two, next slide, please. We have two instances of public interest where there's a permitted general situation and where there's a permitted health situation. So for those two instances, for general situations, these are situations that are for public good. For instance, I think the best example you can give is if you're locating a person reported as missing. I'm sure most of you on social media have been seeing this trend where there's a missing person and people expound on it, post it on, say, a social media platform such as Twitter for the purposes of generating public interest and ensuring that people get to help and notify if this person is missing. Essentially, that's your personal data, because you're having your name, you're having your face plastered on a social platform with wide reach. So on that instance, you can have an exemption from the application of the provisions of the Data Protection Act. And then the next situation is a general health situation. That is the next slide, please. Where we're having collection of health information to provide a health service. Sorry, just a prior slide. When you're having a permitted health situation. So for instance, currently, I'm sure you're aware that every day, given that we are in this pandemic, we're having people collect data and submit it to the Ministry of Health for the purposes of reporting. That is a situation where exemptions can be provided for under the Data Protection Act. But it must be said that at all times, the principles of data minimization and the principles of data safeguarding data, you cannot be exempted from such provisions. That is Section 51 of the Data Protection Act. So I just want to wind up on the question of, next slide, please, on offenses, which will be my last presentation before I invite Jacob and Daniel to take over. So on compounding of offenses, we're just drawing on from the main power of the Data Protection Officer, Commissioner under the Act on compounding offenses. So where the regulations just want to expound more on what happens when the Data Protection Commissioner has decided to take on compounding offenses. The Commissioner is of course required to make the order in writing and give the person who has committed the offense a copy of such order. And the proceedings will not be instituted within 14 days of the order unless you do not, where you do not pay off the fine. And if you fail to pay on the fine, the DPC may institute proceedings against you. So ideally, the idea is to ensure that if you've committed more than one offense in a series of transactions, then those offenses can be taken on together. And once those offenses are taken on together, you will be required to pay a fine. And if you do not pay a fine, you can also be further prosecuted, and you may have imprisonment as a penalty for your non-payment of the fine and also for your breach of the data protection provisions. Thank you so much. I think I'll just call on Jacob and Daniel just to take us to the next session. Thank you.
So, thank you, Nancy. The last of the series of regulations that we cover today is the data protection, compliance, and enforcement regulation. This regulation is intended to give effect to the obligations of the Data Commissioner provided under the Act, and specifically the enforcement provisions under Part 8 of the Act. The regulations are rather unlike the general regulations. Are not there. It's a short, have very precise provisions. It's principally in two parts. We have the complaint handling procedure and the enforcement procedure. I'll just take you through the first part of the complaint handling procedure, and then my colleague Jacob will take you through the final part. So part 2 of the regulation sets out the complaint procedure, and a complaint can be lodged either in writing or orally. In terms of orally, just last week, we saw that Section 56 of the Act places an obligation on the Commissioner to reduce complaints that are lodged orally into writing. There is a prescribed form for purposes of lodging complaints. The regulations also, of course, being compliant with the developing technology. So there's a provision for lodging of complaints via emails or web posting or any other appropriate electronic means. A complaint, once lodged, can be lodged either by in person, so somebody can present a complaint individually, or by a person acting on behalf of the complainant. And I think that is what us lawyers always like seeing in regulations, when there is that express authorization by law to act on behalf of someone else. But also you can lodge a complaint anonymously. And this is important because we are dealing with personal data, and the concept of protecting the details of the data subject is key. But also most importantly is that it could be, the complaint could be in relation to an ongoing relationship. For example, a data subject lodging a complaint involving a breach by the employer while they're still in employment, they wouldn't want to prejudice that. So the provision for lodging complaints anonymously is very critical to that aspect. The regulations also provide the obligation to keep a register of complaints by the Commissioner, and that register should contain the particulars of complaint and are to be filed electronically. It can be in electronic form. But most importantly is once a complaint is lodged, there is a critical aspect of it called screening. And the screening is critical because it helps, it provides a verification process. And it is through screening that then the office of the Data Commissioner will decide on whether to admit the complaint, or where the complaint is not being admitted, then they will advise the complainant in writing that the matter is not within its mandate. Sorry, we were just realized you're on mute. But as I indicated, the regulations, I'll just start from the beginning. The last in a series of our regulations today is the data protection, compliance, and enforcement regulations. These regulations come to effect the obligations of the Data Commission under the Act, and specifically the enforcement provisions which are contained in Part 8 of the Act. The regulations are in principally two substantive parts. That is the complaint handling procedure, which is in Part 2, and then we have the enforcement provisions under Part 3. I'll take you through the first limb, that is the complaint handling procedure, and then invite my colleague Jacob to conclude with the enforcement process. So the Rule 4 of the regulations provide for the lodging of a complaint with the data commissioner, and this can be done either in writing or orally. Last week, when we're dealing with the Act, Section 56 provided that where a complaint is lodged orally, then the data commissioner is to reduce it into writing. The Act also provides for, sorry, the regulations also permit for lodging of complaints via online, by email that is, or web posting, or by appropriate electronic means, just to cover for advancement of technology. Who can lodge a complaint? This can be done by the complainant in person, or by a person acting on behalf of the complainant, or any other person authorized by law to act on behalf of that person. So basically maybe a lawyer acting for a complainant, but also a complaint can be lodged anonymously. And I'm giving the example of, for example, you need to lodge a complaint when there is an ongoing contractual relationship, which you don't want to prejudice. Say you are a data subject in employment and there's a breach or a potential breach by the employer, you don't want to prejudice your position, and therefore you can lodge such a complaint anonymously. It is important that the rules have expressly provided that such a complaint is to be lodged is free of charge. There's no cost tied to it. And after the lodging of a complaint, an entry is made in the register of complaints, which states the particulars of the complaint. And this register should be designed in a manner that protects the identity of the complainant, where a request for such protection is made. After the lodging of a complaint, we move to the next step of screening. And the screening is a very important step, because then it provides the data commissioner with the discretion to verify the nature of complaints. So once the screening is done in terms of the viability of the complaint made, the data commissioner can then either admit the complaint or, where appropriate, advise the complainant in writing that the matter is not within the mandate of the data commissioner, or advise the complainant that the matter lies for determination by another institution or body. And one example is where, for example, we saw in the processing of sensitive data, where you are dealing with personal data relating to health, it can be, that can be processed, for example, by healthcare providers or someone and a professional under guided by secrecy, basically medical doctors. So you could lodge a complaint with the data commissioner, and then this against a health provider or a health professional, and the data commissioner, after screening, establishes that that complaint should be determined by another body, in this case being the Kenya Medical and Justice Board. So that's an example. Or the matter falls within the code of ethics of journalists, and therefore their professional body is supposed to handle that. And there's also a prescribed form for the data commissioner or the office of the data commissioner to refer such a complaint to the relevant body. The instances where the commissioner might not admit a complaint are where it does not raise an issue that falls within the Act, obviously, or it is a trivial or scandalous and vexatious matter. Basically, is a simple issue that doesn't warrant much interrogation, or the complaint is not made in good faith, Upon screening, the commissioner now moves to conduct an inquiry. Basically, this is the investigation process that is expounded on in detail under the regulation. I won't go into the nitty-gritties, but of importance is that where there are two or more complaints that are more related, then they can be consolidated and dealt with together, or one can be stayed and the other one used as a test complaint for purposes of determination. Then the determination on the test complaint will apply to the other similar one. Like the rules of fair administrative action provide, or the right to fair administrative action, when a complaint is made against someone, then it is the Constitution underlies the principle that the person against whom the complaint is made ought to be notified of the nature of the complaint. And the rules take cognizance of this fact and provides for the notification of the complaint upon the respondent, and provides a form for that. The notification should be served either electronically or physically or by post, and you will be required, if you're the respondent, to respond to it within 14 days. And the nature of your reaction, or rather response to it, could be either of three ways. You can either make representations and provide relevant material or evidence in support of its of the representations, or number two, review the complaint with a view of summarily resolving the complaint to the satisfaction of the complainant, or provide a response to the required information. The criteria of responding takes into account the obligation under Article 159 of the Constitution that, in my view, promotes alternative dispute resolution. So apart from the mediation process we will get into shortly, the manner of response required of a data control or data project against whom a complaint has been lodged contemplates that you can deal with it summarily and address it without any further deference to the data commissioner. So after that response, we definitely move to the next stage of investigation. The only emphasis I'll put again is that in the express wording of the regulation, in terms of investigation, the data commissioner is supposed to be guided by the provisions of the Fair Administrative Action Act. And therefore, as a data controller or a data subject, it is also important that you are cognizant of those your rights, so that as the investigation proceeds, it's in a manner that is fair. After the investigation, we'll have the determination, and the determination will be in a manner similar to what a judgment of court will contain. It will have the nature of the complaint, the summary of the relevant facts and evidence that has been adduced, but most importantly, the reasons, and this is also in upholding the fair administrative action requirements, the reasons for the decision that has been arrived at. And then it will provide for the remedy to which the complainant is entitled to. And those remedies, we saw them last week, they're extensive and sometimes very punitive. There could be an issuance of the enforcement notice, the issuance of penalty notice, imposing administrative fines, which we saw up to 5 million, dismissal. Of course, it is the complaint, if it's not merited, will be dismissed. Then there is, again, a possible recommendation for prosecution. And this recommendation definitely will be made to the Office of the Director of Public Prosecution. So breaches of the Act, as the regulations continue to lead us to, attracts criminal sanctions. So it's a very important regulation, or rather regime, that we need to be always on the side of complying as opposed to being afoul of the regulations. But most important, and finally, the decision of the Office of the Data Commissioner on an investigation is binding on the parties, but is also enforceable as an order of court. So the decision of a data commissioner is equivalent to a decision of a court. It has the full force of the law. There is lastly, the part of dealing with complaints, there is a procedure for alternative dispute resolution, and that is negotiation, mediation, or conciliation. And I'll just say that that is supposed to be facilitated by the office of the Data Commissioner, and the office of the Data Commissioner has currently also published Complaints Management Manual, which augments the provisions set out under the regulations that I've just highlighted. I'll now ask Jacob to take us through the enforcement provisions.
All right. Yeah, thank you. Thank you, Daniel. That's useful. And in the interest of time, the enforcement is quite summarized. Under the regulations, and as we discussed last time, the Data Commissioner has the powers to issue enforcement notice in the event that he, on her own investigation or upon a complaint, to issue an enforcement notice for breach, or rather against a breach of the Data Protection Act. And so what the regulations do is they provide a form with a form in which that notice will be notified. And obviously, under the Administrative Action Act, as well as the Constitution, the regulations gives the respondent an opportunity to apply for review of any action that the Data Commissioner proposes to take with regards to any potential or alleged breach of the Act. So the Act the regulations are quite elaborate in the sense that they provide the form just to ensure that there's uniformity as well as certainty on what we should expect should there be a breach of the Act, as well as giving the respondent an opportunity to be able to apply for review of that action. So that is spelled out. The Act also provides for an opportunity for anybody who is aggrieved by the decision of the Data Commissioner to be able to make an appeal to the High Court against that decision. So that's provided for under the Act, as well as recognized under the regulations. The other thing that we discussed last week was issuance of a penalty notice. The regulations prescribe a notice for certainty, the form of the notice, as well as the content of that notice, what should be comprised in that notice, so that the respondent is aware of what the allegations have been made and how he can be able to respond appropriately to that notice. The last provision is obviously the provision that allows the Data Commissioner to enforce any administrative penalty that has been prescribed, the penalty notice. At the last meeting, at our last webinar, we discussed that the Data Commissioner has the right to be able to prescribe administrative penalties for breach of the Act. The provisions of the regulations now give the opportunity or an allowance for the Data Commissioner to be able to enforce those penalties in a civil suit. So basically, that's the enforcement. We believe that this will help in implementing the provisions of the Act, in the sense that it creates a bit of certainty as to what the data subject is supposed to keep in mind in lodging a complaint, as well as the enforcement mechanism. It creates a bit of certainty and visibility in terms of what we should expect going forward. So we think this is a right way, this is an effort in the right direction, and we believe that we should be able to have a clarity in terms of the provisions of the Act and enforcement under the Act. So then I'll take it back to John to open it up for questions and answers.
Thank you very much, team, as well as Madam Kasait from her end for that presentation, which I trust that you have found useful to one extent or the other, and have taken home something from the presentations covered by the various speakers. We shall now allow for a question and answer session. There is a Q&A provision where you can ask any question that you feel needs answering, and we shall then take them one by one. So there is Nathan Joroge, who says, hello, John and team, are you going to circulate to us the slides from the ODPC, Immaculate Kasait? So that's a question for you, Madam Kasait. Will you be happy to share the slides? Or is there perhaps somewhere from which these slides would be publicly available?
Yeah, we will. That's not a problem. We should be able to avail the slides. Anne is on this call on our portal on our website.
Thank you so much.
John, if you allow me, I was joined by members of the task force, and I will be asking them to assist in answering the question. There is Rose Musero, who is an advisor, legal and regulatory advisor in my office. There is Durandira Gatu, who is a drafter from Kenya Law Report. And there's Anne, I don't know who else is on the call, but any questions to us will also, they'll assist me in terms of answering.
Sure thing. And welcome to all those who've joined now. Joyce asks, what about all those unsolicited texts that we get on our phones, yet we had not subscribed? So Madam Kasait, from your team, you can assign anyone to answer that one.
Rose? Rose Musero? Are we not able to lift her? Rose? She's not, she can't answer.
She's not able.
Okay, I guess she's not, she doesn't have the option of adjust and mix the arrangement for that. Anyway, with the new data, we expect that controllers and processors will amend their policies accordingly. This means that they are not supposed to be sending you unsolicited messages which you have not consented to. The regulations have gone to great lengths of explaining the part about consent, what is opting in, opting out, and what is expected of you. So as it is, when you receive unsolicited messages, it goes against the spirit of the Data Protection Act. Unless you were a customer and consented to receiving such messages from the data controller. I hope that helped answer the question.
No, I think that is exactly what I'd have said to that. It really is a question of tracking back. If you visit a shop and you make a payment, and suddenly you're being bombarded by this unsolicited text messages, go back and try and remember, is there anywhere where I gave my consent? And if you get that consent, was it compliant as far as the Act requires consent to be set up? If you think you didn't give that consent, then there you are. That's a perfect example of a data violation. So in that case, you're then enabled under the regulations to lodge a complaint against that entity. And remember that the burden of proof of consent is now shifted to the other side. So if they're the ones relying on consent, it will be for them to prove that you gave consent. So Joyce, I hope that answers you sufficiently. The next question was from an anonymous attendee regarding transfer of data outside Kenya. Is an entity required to notify the data commissioner each time they are transferring data? How often should it be done? What is the practical way to go about fulfilling this requirement? So when transferring outside of Kenya, do you require consent every time you do so? And how often, if that is the case?
I think the regulations have guided on that. And one of the biggest feedback we got during the public participation is in terms of data transfer between companies which have branches abroad. We have looked into it. Once we complete the process, we should be able to share with you. But the fundamental thing about transferring data outside the country is sensitive data. It's actually consent. That is a fundamental issue. It's important to get consent. And if you say how many times, it will assume that you have consent throughout. It's important to remember that you could be getting information and transferring of different people at different times. Therefore, you will be expected to seek consent as it is. Thanks.
Yes. Can I add? Yeah, just to add to what the data commission has said is that in the instances perhaps where, just to give an example, you are hosting employee data or your customers' data of outside the country, for instance, in a server outside the country, then this is a perfect, a case where you need to do a data impact assessment in order to assess what are the implications, what are the measures from a technical perspective you are putting in place to ensure that where that data is hosted, it is secure. And therefore, once you've done that assessment and you've given the proof to the data commissioner that actually, you put in place proper measures to ensure that their data is not disclosed unlawfully, then obviously every time you engage an employee, you might not need to apply again for proof because already you've put in place measures, you've done a report, and that report is presented to the data commissioner, and therefore for subsequent transfer of that data or storing of that data in the server, you've already done an assessment which the data commissioner has approved. So that lessens the burden of ensuring that every time you engage an employee and you need to transfer that data outside, you need to apply afresh. But obviously, as the data commissioner said, consent is very key. So at that time of onboarding that particular employee, you need to obtain his consent for that data to be transferred, transferred outside Kenya. But it's a classic example where a data impact assessment would need to be done so that subsequently you don't need to apply for another approval from the data commissioner once you transfer that data.
Thank you for that.
I don't know. John Rose is now on board. I don't know whether she wants to add anything on that issue.
Sure thing, Rose. Go right ahead.
Thank you, Madam Kasait, and thank you, team at Oraro. Yes, just to give clarification on this, no, you don't have to keep coming to the Office of the Data Protection Commissioner whenever you need to transfer data outside of the country. I think the requirement is that you do so for one specific, so your application or your request to the Office of the Data Protection Commissioner will deal with a specific purpose in which you're transferring data, like has been mentioned. Say, for example, if you're transferring employee information and it's all for the same processing activities, yes, it's recommended that you do a data protection impact assessment, especially if you're looking at instances of capturing sensitive information, or say, for example, you're doing psychometric testing, which has become a very common practice for organizations to do when onboarding, because this actually does capture to some extent the thinking and beliefs of individuals. And so that would, to a varying degree, class as a sensitive personal data. So you do need to measure up what the provisions are in terms of lawful processes, ensure that or lawful basis for the collection of information, but you do not have to come to the data commissioner every time. So you onboard an employee as long as you're following the same sort of routine for that processing. If you're transferring to one country and that country has been approved by the data protection commissioner and she's given a go ahead for you to transfer that data, then next time you get someone else that you're transferring that information from, as long as you've got a paper trail of some sort to indicate that you've received consent, or you have a lawful basis, or there's a contractual agreement, and it's for the purposes of that of performance of that contract, then you do not need to keep coming back. I think that would be a tedious process for the ODPC as well, dealing with several requests regarding the same processing activity. Thank you.
Sorry, the next question comes from Wangui Mungai, and she asks, she has a few questions. So number one, how do we deal with collection of personal information when entering a building? Do they have to register as data collectors? So this is the typical book where you put in your name, sometimes number and ID. Do those people have to register as data? They are collectors, but I assume she means so maybe we can take that question first before we get to the second limb of her question.
Rose?
Yes, thank you again for that question. The issue of access to buildings and the collection of information actually is captured in two specific legislations. So the first is the Private Security Authority Act, which gives private security organizations the mandate or the power to collect information for the purposes, obviously, of security, and so they're required to do so. However, the Data Protection Act provides that in so doing, they must notify, or they have a duty to notify those who are entering the building of their rights, and this is, I think, set out in Section 29 of the Act, which effectively gives data controllers who are collecting information the duty to notify anyone who they're collecting information from. And so this duty to notify includes advising of why they're collecting the information, advise of how they will be storing that information, advising of the rights of the data subject. And so effectively in practice, buildings should be able to adopt either privacy notices in accordance to what the draft regulations suggest at the moment, because they're not regulations that are fully in place, or advise their security personnel to ensure that each person who enters a building is fully informed of the reasons why their information is being collected, and give data subjects the ability to at least understand, not necessarily give consent, because there is another statutory obligation upon the privacy security firms to take this data in the first place, but at least to ensure the data subjects are informed of the reasons why this information is being collected from them.
Thanks for that. And then the other part of the question was, what about the overlapping roles between the Office of the Commissioner of Data Protection and the Registrar of Persons and the role of the Kenya National Bureau of Statistics? So is there an overlap in those roles? And if so, how is it then resolved?
I don't see it. Rose, you want to go ahead? Just go ahead, please. Go ahead.
Thank you. As Madam Kasait has started to say, there is no overlap between those particular organizations or institutions and the acts that give them the mandate to collect information. You will note, for one, that the Data Protection Act is an overarching legislation that deals with data protection, and so everything touching on personal data within the Kenyan ecosystem is actually dealt with under the Data Protection Act. However, this is not to say that there are some instances where there will be not an overlap, but there will be a need to balance rights that are in different statutes. Say, for example, issues that we've talked about private security and things like that. You'll also notice that there's actually regulations that deal with civil registries. So there is a data protection civil registries regulations that were enacted, I think, on the 16th of October 2020, that should be available online, and they deal with how civil registries, and they do identify the civil registries specifically, and how they should be managing data, how they deal with data protection impact assessments, how they deal with safeguards, and the like. So there is no overlap with those, because these civil registries do have a mandate of collecting information for the purposes of record keeping, as well as ensuring that citizens have documentation that assists them in getting government services or just essential services that are provided by government, the government of Kenya. In terms of the National Bureau of Statistics, again, there is no overlap in collection of personal data. The KNBS does need to adhere to the Data Protection Act. However, in collection of the information that they require to do or to perform their mandate, they can rely on the statute that enables them or gives them that mandate. And so they do not need to necessarily seek consent unless they're going above and beyond in the collection of that information. But they still need to ensure that the other obligations, such as the duty to notify, the obligations to deal with the privacy by default or design, data protection impact assessments, if they're doing anything that's of high risk, are taken into account even as they collect survey data. However, you will also note that in terms of the statistics that they publish, which is not deemed to be personal identifiable information, is not actually captured under the purview of the Act, and so the publication of their survey data is something that is exempt from the application of the Act due to the fact that it does not capture any personal identifiable information, but the storage of information that's captured directly from individuals needs to be protected. Thank you for that.
Nathan Joroge has another question. Is it implied that organizations will be required to have local data centers? What is being referred to as a primary data center in certain places in the Act and the draft regulations?
I can take that as well. You will note that in terms of localization of data, the draft regulations have actually captured specifically certain organizations, which majority of which are actually government institutions. And the reason for this obviously is there are a number of reasons, but I guess the primary reason for this is so that there is accessible data in the country should anything happen. So say, for example, in terms of elections and things like this, there's always a data set that is maintained within the country. There is no restriction on cross-border transfer of data as long as there are safeguards that are put into place. And so a number of organizations, in fact, most organizations that are not government entities, do not necessarily have to consider this obligations of having a primary data center and can rely on their local data service to be able to do their backups and what have you. Although it's encouraged for obviously economic reasons that that data be stored locally if at all possible. But in terms of having a primary data center, I don't think I've seen that specific definition within the draft regulations, and this would be contained in the general regulations. Pardon me if I have if I recollect incorrectly, but I think that it's not required or implied that organizations should have a local data center. You'll also note, I think Madam Kasait touched on it in her presentation, that in terms of data localization, what the task force has opted for is and this is under Regulation 25 of the draft regulation, which currently puts I think the connecting word that has been used is "and," so requiring government institutions to either have a local working data set currently within the country, and to also process data locally. We at the task force have deliberated on this and found that it is a bit restrictive, and we have opted for a non-exclusive data localization sort of application. And so that word "and" has actually been changed to "or," so that organizations can do one or another, either process their data locally or have one serving copy of that data locally. So not necessarily both. But as I said, this generally just captures government organizations mostly. And so a lot of private sector organizations are kept out of this based on the sector in which they operate.
Fantastic. Then there is a question from GO Initials. Are there any instantaneous actions from the Commissioner's office pending litigation in case of a data breach? I think basically they're asking, have there been any complaints made in terms of data breaches that the commission?
I think beyond litigation, there are very many other aspects that the law has provided, whether it's an audit, inspection, whether it's an advisory, whether it is, there are many options that are provided for beyond litigation in as far as the Data Protection Act is concerned. And like we keep saying, the focus now, although it's awareness creation and compliance, there is also an issue about issuing an advisory. And some of the issues that are emerging, we are also embarking on issuing advisory or giving advisories to different institutions on how to make sure they are actually compliant with the Data Protection Act.
Okay. Then Lavina Yisi asks, when are the regulations coming into force? Will there be a compliance period, a grace period, perhaps, for compliance?
We hear that question a lot, John. Everyone wants to ask about a compliance period. In fact, others say in the case of GDPR, they had 1 year or 2 years of compliance. And when you tell them even this one has been enforced for 2 years, I like to answer this question philosophically, like to say that unfortunately, when the Data Protection Act came into force in 2019, that must have been left out in terms of the compliance period. It's assumed upon breach, then therefore there'll be a redress coming from the Data Commissioner. However, as an office, we are cognizant of the fact that as a country, we are in the stage where data protection is a completely new concept. People freely share their information without asking who they are giving, what it is for, and where it is headed to. Therefore, as an office, to be able to address this gap of where we are expected to embark on enforcement in a place where there is still a lot of, for lack of a better word, understanding on data protection, we are embarking on an awareness creation as our priority and compliance. So that even as we then, when we begin asking questions about enforcement, the stakeholders, in this case, data subject, data controllers, data processors, have an appreciation of what is their data, what it is used for, how to store it, what questions to ask, and their obligation and rights under the Data Protection Act. I hope that helps answer the question. Thank you.
Then the final question is from Michelle Quacker. Hi, there is a lot of talk about responsibilities of data processors, including buildings, reception, collecting data, M-Pesa agents, etc. Is there a plan to do public awareness for all these persons? I think you'd already answered that, but maybe for Michelle.
Yes, I have.
Maybe just perhaps Michelle might not have been present. If you can just highlight again briefly for her sake.
Yes, I will repeat it for Michelle's sake that we as an office, and I'll give an example. When we realized it was important to change strategy and embark on awareness creation and compliance, is when you have conversation with people, they still freely share information. I like to give the example of recently when there were complaints about political parties, people being registered when they had the consent had not been sought. We did write as required, as part of the steps, we did write to individuals to tell them we have received your complaint. The irony of it, the people who were complaining that the information was used without their consent were the first one to publish it on Twitter, say, I got mail from DPC. And they blocked their email address, but they still left their detail. That tells you in terms of a culture of a country, we are still not there in terms of embracing the culture of data governance, data privacy. We are not there yet. And therefore, as an office, our priority, I say again, is compliance, 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 awareness, awareness, compliance, awareness, compliance. Because so that when we embark on enforcement, we are talking to a population that has shifted their mindset in terms of what is expected of my information, where is it going to be saved, am I required to get consent, what are the parameters of when my information can be collected and how it will be utilized. So Michelle, that is our priority. We are in the new financial year, we are partnering with other people, and I said, I was glad to come here today. And I really thank John for reaching out to be able to come and speak to you, because this is part of our awareness campaign. You will be seeing more of this later in the year when we have messages, when we have embarked on discussion with Kenya School of Government to see how many people we can bring on board who are the big data sector, collaboration with many people in terms of this issue because I believe as an office, we cannot say we are we have what we will educate the public alone. I think it's an area that requires collaboration with different stakeholders and different partners. And that is what we are pursuing at the moment. And indeed, awareness creation is our priority and it is our business because we want to shift the mindset of Kenyans from becoming sensitive in terms of what information they share and how and who and when it is used.
So thank you so much once again, Madam Kasait and Rose, for joining us. Your role today has been invaluable, and we thank you from the bottom of our hearts. We wish you all the best as you proceed with your role under the Act. I am sure you will continue doing a stellar job, and thank you once again. Also, thank you to all our attendees for making time to join us this afternoon. We hope you have taken away one or two things and that your level of awareness, as Madam Kasait has emphasized, has improved over the course of the two webinars that we have had. Our BD team will share with you the slides for those who are interested. You can drop an email requesting for the slides on our Insights page, and then we shall receive the slides. So thank you once again and have a good rest of the day.